Good morning. My name is Elliotte Kahler, and my presentation is a comparative analysis of the key differences between the Canadian and American systems of personal injury compensation. So just as a quick overview, I'll be talking about just what the law is, the four differences, and then just some final takeaways. So first, what is the law? Well, the Cambridge Dictionary defines the law as a rule, usually made by a government, that is used to order the way in which a society behaves. The law protects our citizens, provides personal responsibility, and stabilizes the government. There are 5 types of law consisting of religious, customary, mixed, and civil and common, which I'll be talking about today. So civil law gets its origins from the Romans and is used primarily in Europe, and it is codified, which means that the government uses a strict code to dictate how to deal with disputes. So someone breaks the law, they look to the code to deal with it, and they resolve it using that code. Common law is used in both the United States and Canada and gets its origins from the Middle Ages in England. And it is adversarial, which means 2 parties will go before one judge. The judge will dictate how the case is resolved. So it's more based on interpretation and opinion rather than a strict code. Not only are the United States and Canada similar in the way that they're both common law countries, but they're also similar in how they have the law laid out, which is using a constitution and a Bill of Rights. Although Canada's Bill of Rights isn't inside of its constitution like in Canada, they both have a set of documents to lay out what the law is and what all future laws have to agree with. One of these things that it lays out is what courts can hear what cases, which is known as public and private jurisdiction. Public jurisdiction is when an individual disrupts a society, and an example of this would be criminal law, where an individual disrupts a society by breaking the law, and in turn, they receive jail time or fines. Private jurisdiction is when an individual disrupts another individual, and an example of this would be personal injury law, when someone is hurt and they sue the other person for hurting them. So, these 2 systems differ in 4 major ways: the role of the federal courts, damages, costs, and negligence. And so why learn about this? Well, comparing the 2 systems will show how impactful and strenuous an injury is, and that although there are major differences, they're equally valued. So first I'll be talking about the role of the federal courts. The federal courts have the ability to apply, interpret, and determine laws to cases. And a plaintiff's right to bring their case to a federal court largely depends on their location. In the United States, in order to bring your case to a federal court, you need to have subject matter jurisdiction, which just gives them the ability to hear the court. And you can get this in 2 ways, through diversity jurisdiction or federal question jurisdiction. Diversity jurisdiction is when there's a diversity of citizenship in the case and the damages exceed $75,000. So let's say in an accident, there's a citizen and a non-citizen, and the damages exceed $75,000. That case would then go to the federal court. Federal question jurisdiction is when there needs to be an interpretation of the Constitution or a federal policy. And an example of this is the Jones Act. The Jones Act protects seamen who are working when they're injured due to negligence from their employer. And since the Jones Act is a federal policy, it would have to go to the federal court. Canada, however, the federal courts are much less accessible. They'll only hear personal injury claims which arose in the shipping and international trade, like the Jones Act. And this is due to their 3-court system, which tries to prevent cases from going all the way to trial. There are provincial and territorial courts, provincial and territorial superior courts, provincial and territorial courts of appeal, and then the Supreme Court. And then within the Supreme Court, there's the federal courts. The federal courts don't actually have jurisdiction over all the cases like the provincial and territorial courts do. So in all, they're really not qualified to deal with as many cases. And also, 90% of personal injury cases are actually settled before going to trial. And this is due to pretrials to try to bring a faster settlement and closure for the victim. So what does this mean? Well, having to wait on a case to be closed is extremely painful for a victim, especially if they're put out of work or dealing with PTSD and isolation and depression. So by having access to the federal courts in the United States, it can lead to a faster closing time and a quicker close to the case. As well as in Canada, having access to pretrials also brings that same ability to have a quicker close. So how does this encourage safety? Well, by understanding how damaging and distressing the trial process is, and realizing it is not something that you want to have to deal with because of taxes and costs and fees, which I'll be talking about later, it should strive to push drivers and organizations to avoid the process altogether. Next, I'll be talking about damages. Damages are monetary awards given to the victim of an accident. These differ dramatically depending on where the accident occurred. There are two types of damages, punitive and compensatory. Punitive damages are used to punish the defendant for acting either negligent or malicious. And these are much more common in the United States than in Canada. We see these in drunk driving accidents, but also in a funny case where a man had hot coffee spilled on him in McDonald's, sued for $160,000 in compensatory damages, but $2.7 million in punitive damages, which in today's money is $5 million, so that was kind of crazy. Although there is an exception in Canada, if an insurance company unreasonably refuses to pay a victim for obvious suffering, then these damages will be awarded. Then there are compensatory damages, which is the main source of relief for a victim. These come in economic and non-economic damages. Economic damages consist of recompensating the victim for medical bills, therapy, and rehabilitation. And the non-economic consist of pain and suffering and impairment of quality of life. And these non-economic damages is where the United States and Canada differ. In the 1970s, Canada saw how inflated and out of proportion the United States' non-economic damages were and decided to cap their limit at $100,000, which in today's money is around $400,000. But in reality, what they actually receive for these damages is far less. So typically, we could say that the United States is entitled to more non-economic damages than in Canada, but many times, in a lot of cases, theory and reality differ. In Canada, there's a $1 million insurance limit on drivers to be able to drive their car. In the United States, this is only around $10,000 to $20,000. So if a United States citizen got into a car accident, their case could be worth millions of dollars, but if they only have $20,000 in insurance, that's all they'll receive. Whereas in Canada, normally victims are compensated rightfully, and United States victims are undercompensated. People normally assume that insurance will cover all damages, but that's not the case. Not only are there damages, there are also costs that go into a lawsuit, which I'll talk about, and somebody has to deal with compensating the victim for all these damages. So the US and Canada also have different rules governing how and what lawyers are paid and all of the fees that are accumulated during the process. Some of these costs are court fees to file your case, the cost to obtain records, and expert opinions, which oftentimes are the most costly. And then also, of course, you have to pay your lawyer. Lawyers are paid either hourly or on a contingency fee. And a contingency fee is where the lawyer will charge 25% to 40% of the final settlement. So who pays for all of these costs and damages? Well, there are two rules depending on where the accident occurred. The English rule is used in Canada, and it dictates that the losing party will pay for the winning party's costs. Using this, Canada tries to discourage frivolous lawsuits from going all the way to trial and also ensure that the victim is fairly compensated. The United States has a different rule, and they use the American rule, which dictates that each party will pay for their own costs. Using this system, the United States tries to be more fair and encouraging people with legitimate lawsuits to file them without having to worry about paying both fees if they end up losing. And in theory, this makes a lot of sense, but it also can lead to a lose-lose situation. For example, there was a dry cleaner who lost an item of their customer's clothing and was sued for it. He ended up winning the lawsuit, but still owed $100,000 in legal fees after the fact, so he didn't really win. Being aware of how expensive costs are should encourage people to be more mindful of their actions to avoid having to pay a large sum of money that they may or may not have. So it's important that being vulnerable to these costs is aware so that it can be avoided in the first place. Lastly, I'll talk about negligence. So in a lawsuit, there's a plaintiff and a defendant. The defendant is the person that harmed the plaintiff, and the plaintiff is the victim. In an accident, it's important to know that the defendant was the one who caused harm, but it's also necessary to assess whether or not the plaintiff had something to do with the injuries of the accident. So for example, let's say there's a car accident and the plaintiff was not wearing a seatbelt. Because the plaintiff was not wearing a seatbelt, it didn't cause the accident, but it will lead to further significant injuries. And so, to deal with compensating the victim fairly for their share of responsibility in the accident, they came up with contributory negligence. That's what it's called in Canada, and this just means that the victim will only receive the percentage of the settlement that they were not responsible for. So let's say the plaintiff was 20% responsible for the accident and the defendant was 80% responsible. They would only receive that 80% of the entire settlement. The U.S. has 3 modifications to this rule depending on what state you're in. They have pure contributory negligence, pure comparative fault, and modified comparative fault. Pure contributory negligence is active in 4 states, and this says that the plaintiff has to be 0% responsible for the entire accident. So the defendant has to be 100% responsible. However, there is an exception. If it's found in the trial that the defendant had the last second to avoid the accident, like in a car crash, and didn't, they cannot claim pure contributory negligence, and the plaintiff can still receive these damages and awards. Then there's pure comparative fault, which is used in 13 states. And this is very similar to Canada's, and Florida is part of this, that says that the plaintiff will only receive the percentage that they are not responsible for in the accident. Then we have modified comparative fault that uses a threshold rule. And what this threshold, depending on what state you're in, could be either 50 or 51%. So it says that the plaintiff has to be below the threshold to receive damages, and they will only receive that percentage of the damages that they weren't responsible for, so much like Canada's and pure comparative fault. So in all, knowing that if you're negligent, all the blame will be placed on you. And so I think that's more than enough motivation to try to make sure that you are not responsible for an accident and responsible for paying all of these damages and costs. On the other hand, if something does happen and you're not at fault, knowing these different policies will put you at ease, knowing how the system works and that it will be working for you. So in knowing about negligence, you can prevent it to the best of your ability, and if an accident occurs, you can be sure that it won't be pinned on you. So just as some final takeaways, systems of personal injury compensation are very important for citizens wherever they live. Court is a long and strenuous process, especially if you're put out of work and don't have a steady income. Being reckless will only result in grave consequences and high expenses for you to pay if you're found to be negligent. Expenses that go into fighting in court can lead to more harm than help economically. Accidents happen all the time, so it's important to know how you can use the system to your benefit. Despite the proximity of the United States and Canada, it's interesting to see how the systems of compensation have developed differently. Even though they've developed differently, in the end, they both strive to compensate the victim of personal injury to be able to recover to the best of their ability. Thank you.
Okay, I'm going to open it up to questions.
Yeah, what made you choose U.S. and Canada? Like versus like to common law versus like common and civil. What was your interest in?
Well, I'm originally from Canada, and so it obviously was just interesting to see that I moved like 10 years ago, and normally you think that they're so close, you think that everything is similar, and then also with my interest in personal injury to find that they were different, I just found it really interesting that.
Do you know what is Mexico? Do you know?
No, I don't know.
I don't know what it is.
My research.
This is all new to me.
Yeah.
If you had to give advice, one thing the United States should copy from Canada, if anything, what would it be in terms of personal injury law?
I would say upping their insurance policies because, although it might be cheaper to drive and afford insurance, if something does happen, because you can't predict when an accident occurs, that you'll be it's like a safety net, and that a lot of Americans don't know that if they're in an accident and it's more than their insurance covers them for, then they're stuck and they won't be able to receive a fair amount of compensation. So I would say upping the insurance policies.
Minimum amount of insurance.
Yes.
Do you know what it is in Florida? How much work required to carry?
I think it's around $10,000 to $20,000. But
Do Do you see pressure or interest in further development of how these systems of compensation work in either Canada or the U.S.? Do you see that developing in the near future, or do you see kind of a push towards adapting these systems?
I think so. This summer I interned at a law firm, and it was interesting to hear that one of the lawyers I was talking to was kind of like speaking poorly about the law and how it didn't properly serve victims, and although it tries to, it doesn't always. And so I definitely think that both the United States and Canada could learn from each other and kind of bounce off each other's policies to try and find like the most fair and right way to compensate victims of injuries and accidents.
What is this is the issue of personal injury is controversial and topical. The problem is that the people who oftentimes make the decisions in terms of reform are themselves lawyers, and lawyers oftentimes have a vested interest in maintaining the system of compensatory processes to give people, settlements, so that's how some of them make their money. So you basically have the inmates running the asylum, so to speak. And there's an argument that's made by countries that have less litigious societies that, one of the problems of doing business in countries like the United States or countries that have a lot of protections built into the system for, you drop coffee on yourself, and so we have to pay you now $1 million because you were careless, or you fell in front of my house, and that's my responsibility to take care of you because of that. And I'm not saying that that's not necessarily true. I'm not here to litigate all those things, but there are countries where that doesn't exist. It would be interesting to know how they get by, and what it's costing the citizens of countries who live in litigious societies to maintain all this. Certainly lawyers are doing okay, but what is it costing business? What is it costing society to have all of these lawsuits?
Right. I actually thought that was really interesting. I found in my research that I think a lot of big organizations and societies are really focused on not getting into lawsuits and like having to sign waivers to ensure, like when you go to trampoline park, you're kind of signing away your rights. And so I think that there kind of is this stigma now that you have to kind of like sign away your rights, and that you have to accept that these people aren't responsible. And I don't know. I think that having lawyers, come up with the law, like you said, of course we can hope that there is no bias, but there may be. So unfortunately, I think these are just like unintended consequences of just the system.
Is there a difference? State law is oftentimes at play here more than federal law. So are there differences between the states in terms of compensatory and any of the damages that are allowed by states? Are there states that are not as generous, and other states where, I suspect that there are certain states where this is a big issue, California being one of them. I don't know why I think that way, but I suspect. But are there states where, they expect you to be, something happens that they don't, the law isn't set up so that people automatically get damages. It's a little bit harder bar. Do you know if that's true? Within the provinces of Canada, are there differences?
They're in Quebec, so Quebec is actually a civil law province because of their origins with France, so I'm sure that they handle things a little bit differently. I know in the States, like when I was talking about the modified comparative fault state, or the pure contributory negligence states, which is Maryland, Alabama, North Carolina, and Virginia, and they don't award any damages unless it is like someone is really at fault. And so I think in that sense that they don't just throw money at people, And also in the United States and Canada believes in compensating the victim to get them how they were pre-accident. But the US kind of has this philosophy of trying to set up the victim kind of better than they were pre-accident and to set them up for the post-accident. So I think looking at it that way, that Canada is kind of undercompensating the victims, whereas the United States kind of in its entirety tries to give more money to victims, but I couldn't say for sure state by state.
On the same note, I think the damages, the insurance liabilities that you have to sign up for, they're different. Like in New York, it was different, and it was actually lower here in Florida. But the cost went up for me. Like, do you think there might be a reason for that? Like, the insurance premium went up for me when I moved to Florida.
Oh, really?
Yeah, even though they are not giving me as much, coverage.
Yeah.
Do you
Car
think there might-
insurance.
Yeah, car insurance.
Right. Well, I think that maybe this should try to inspire insurance companies, especially in Florida, to.
Well, they are leaving, right?
Yeah.
Yeah.
Maybe these things called hurricanes.
I think the demographics of this place might cause,
I would agree with that.
more
Yes.
claims.
Yeah.
More claims.
Yes.
Elliotte, how you mentioned in your presentation that you were interested in law and personal injury. How has your research impacted that desire to continue? Do you want to become a lawyer one day after doing all of this? Is this an area that you might want to specialize in?
Yeah, definitely. I think I want to go into law, but this has kind of inspired me. Like, now I know a lot about personal injury, but it's such a small part of like the entire legal process. So now I'm just hoping to learn more about even more types of law, like criminal, and it's kind of opened my eyes as to how much there is more to learn.
I was driving to Connecticut once and I saw tort museum and I saw that tort in your paper also. What is it?
Sorry?
Tort law? What is that?
Oh, tort law? Tort law is just another word for like a civil law case, so like personal injury law, which is like a private jurisdiction, like individual.
Non-criminal.
No.
Non-criminal.
Yes,
Right.
not a criminal. Yes. Okay. Thank
Is
you.
it? Okay.
Thank you.